In law school, starting in the first year, you're going to encounter something called the case brief. In this video, I'm going to talk about what the case brief is and one approach for creating a case brief. It's not the only approach, but it certainly is one that I highly recommend. Now, a case brief is essentially a summary of a case. It's a breakdown of all the important pieces of it, the holding, the precedent, and it's also an opportunity to give it a critical review. It's a way in which you might use a case both for your law school exams as well as for a client. A case brief is a useful tool throughout your law school experience, especially as you're trying to understand how the cases fit with one another. But the skills that you develop in creating a case brief are also ones that you will use when you're a practicing attorney. So I highly recommend that you give it its very best effort. Now, as time goes on in law school, you may find that you can't brief every single case. There won't be enough time to do so, simply given the number of cases that you'll have to read. So you may need to adjust some of my recommendations here for your own personal use. Among the things that are most useful out of a case brief, though, is looking for ways to spot the holding and to use it effectively in your answers on a law school exam. So let me show you how I might develop a case brief. This is an example that I use in my classes, in which if you've taken any courses from me involving a law or constitutional law specifically, you've probably used something like this. The case brief essentially looks something like this, and I have taken this case brief and I'm using one example of a case title here. This is the Cruzan case, Cruzan versus Director of Missouri Department of Health. It's a case that involves the right to die, or colloquially the right to die. A better way to think about the case, though, is the ability to withhold life-giving medical treatment for a person who is most likely terminal. It's a really important case involving the right of privacy, and it's a very hard case to understand if you're not reading it carefully. So what I've done here is I've set up my case brief to break down individual pieces of it. The way I think about a case brief is there's kind of two parts to it. There's what I would refer to as the right-hand path, or the path that's traditional when it comes to case briefs, and I'll go over each of those pieces in just a second. And then the other part of the case brief that I like to talk about is what I call the left-hand path, or the critical side of things, looking at the more subjective approach that you would give to a case, the things that you find valuable from it, and the way in which you might think of how it fits within the law and ways to change the law, to improve upon it. In other words, the left-hand path is essentially saying, well, this is what the Supreme Court or the court I'm reviewing thinks about the law, but how should they be thinking about the law, in other words? So let's look at this right-hand path for a second. In most models of a case brief, you'll see similar pieces. This is, as I say, the traditional approach to a case brief. And although you may adapt your case brief to your own personal preferences, I highly recommend that you include most of the things that you're going to see here on this first page of my case brief. The reason being is these are the ones that help you not just on your law school exams, but it's the kind of things that you're going to find useful in advising your clients and writing memoranda as a practicing lawyer. It's also the kind of things that you're going to be putting in legal briefs. Using this kind of information helps you understand how a case might be relevant for arguing at trial or before an appellate court. So the first part of the case brief itself is identifying the facts. The facts are really what inform the decision of the court. Although the Supreme Court is not digging into the facts for evidentiary purposes, something I describe a little bit more in my video on reading cases, the Supreme Court nevertheless has to refer to the facts, and the facts are what is essentially driving the conflict. So we want to know what the parties are actually caring about in this case. After all, without the parties and without their conflict, there would be no case. So the first person you want to look at is the appellant. Now, this is the person who has lost at some stage in the trial or some stage in the case history. Usually it's the person who has lost at the court that's previous to the reviewing court. So let's say this is a Supreme Court decision. This is the one involving Cruzan. In this particular case, it involves an appeal from a state Supreme Court decision, the Missouri State Supreme Court. And that court has concluded something. The appellant of this decision is whoever lost at that state Supreme Court level, or if it's a federal circuit court, whoever lost at the federal circuit court. Now, sometimes that person might be the exact same as who lost at trial, too. Maybe they lost both rounds. So, for example, let's say it's a criminal defense case, and the criminal defendant was found guilty. They appealed their sentence to the appellate court of their state, and they appealed it to the Supreme Court and it's the Supreme Court of their state, and it's very possible that they lost at all of those stages. If they're choosing to also appeal it to the Supreme Court, they are the appellant. They're the person that's bringing this case to the Supreme Court. Now, you don't want to get that confused with plaintiff and defendant. That's only at the trial level. The plaintiff is the person that's bringing the case to the trial court. Usually in a civil case, they're suing somebody for damages or a breach of contract. And then the defendant is the person that they're bringing into court, that they're leveling accusations against. Or if it's a criminal case, it's the prosecution, the government, that's prosecuting a person for a crime, and then the defendant who's having to defend against those accusations. You don't want to get those terms confused with appellant and appellee. Appellant is just the person who's appealing the decision. They're bringing it to the Supreme Court. You want to ask, what are their interests? Why are they mad? What's brought them to this point to begin with? And here in this first part, you really want to dig into why it is that they even care in the first place. What got them to this stage, and why are they asking the Supreme Court, or whatever court you're looking at, to weigh in on this subject? Then you want to do the same for the appellee. The appellee is whoever they're appealing against. It's the person that they're bringing up to the Supreme Court or the court that you're looking at. The appellee is the person who has most recently won. They're the person who really wants to go home and say, we're done with this case because I'm satisfied with the way in which it's been resolved. Here in the Supreme Court case, it's the person who's got the highest stakes. They really wanted to defend the position of the lower court, and they want to prove that everything is just fine, we can go home happy. So you want to look at their interests too. Now, the reason why you're looking at both of these is because the facts are driving the decision. Sometimes the facts matter greatly because there's a certain amount of justice that's trying to be done here. Which party is most harmed? Which party deserves to win are some of the key questions you might want to look at, because those are the ones that the Supreme Court might be wanting to look at too. So once you've figured out the facts, then you should also look at the procedural history. So how did the parties get here from the very beginning? So unlike just the most recent appeal, the procedural history is asking you to look all the way back at the beginning. And I include here what the parties might have decided before trial. Sometimes they may not have decided anything, in which case your answer is, I just don't know. Sometimes parties may have agreed to certain things. They might have tried to go through mediation or arbitration. They might have tried to negotiate beforehand a settlement, and all of those things broke down. They may have even tried to do things that didn't involve the law in the first place. Like, for instance, they might have used the political system to try to help them. They might have gone to Congress or their state legislator, or they might have reached out to their governor, or maybe they worked with an administrative agency to try to resolve their problem. All of those things might be relevant because that's what the Supreme Court, or the court that you're looking at, is going to refer to. All of that builds into the timeline and tells a story as to how the parties actually got to trial. Then you want to look at the trial court. What did the trial court decide? What was the kind of evidence that got brought in? Who won at the trial court? What did the trial court judge think when it came to the matters of law? Did the trial court judge cite the law correctly? And what did the jury return in terms of a verdict? Were there any things that happened after trial, like post-trial motions or new evidence that was brought in? Was there a overturn of the verdict, and did they go back and restart the trial? All of those things are perfectly possible. Now, the reason why you want to look at that is because eventually this case is going to go back to the trial court in some respect. So let's say that the Supreme Court affirms the decision and says, yep, the trial court got it right. In that case, the trial or the case is going to go back to the trial court for an order, and there's going to be an enforcement of that order. So eventually it's going back to the trial court judge who's going to enforce whatever the Supreme Court has decided. Or maybe the Supreme Court's going to reverse the decision, in which case maybe the verdict is thrown out, and then the trial court judge has got to decide what to do with it now that it's been reversed. It may even be possible that the case just gets thrown out completely, but the trial court judge has to be the one to do that. Understanding that helps you understand that Supreme Court decisions are not just the final stage. It's not like the finish line has been reached and nothing else is going to happen. You want to know what the trial court's responsibility in all this is, how they got to this stage, and how they're going to get back there. Then you want to look at all of the courts that are in between. So after trial, what was the verdict? who appealed that decision, where did they go to appeal that, and what are the various courts and their holdings throughout the whole piece. At many, many stages, there could be lots of different courts that have looked at this. So for example, if it's a federal trial court, there's been a verdict, and that a person who loses at that trial might appeal it to one of the circuit courts. The circuit court might look at it, and 3 judges might conclude one thing about that decision. But then there may be an appeal that's called a per curiam decision, or an en banc decision, in which all of the circuit, all of the judges sitting in the circuit, have to weigh in on the decision. So it's almost like a mini appeal within an appeal. And then by that time, it might go to the Supreme Court for a petition for a writ of certiorari, which is an opportunity for the Supreme Court to say, yeah, we're willing to look at this case. So lots of things could happen between trial and getting to the Supreme Court, and lots of judges might have weighed in at that point, judges who are equally capable of looking at the law. There also might, from a state level, there might be many, many even more trials or courts that have looked at it between the trial court and now. So you want to be able to sketch out the trajectory, because you want to be able to see who got the law right and who got the law wrong. It's also an opportunity to see where the ambiguity is. In many cases, once it gets up to the highest court, there's really an open question. We're not entirely sure what the law is, and there's some deep conflict as to how the law should be resolved, especially in constitutional cases like this one involving Cruzan and her right to die. It's an open question. We're not entirely sure what the Constitution says about this. And so you'll see in the procedural history many courts wrestling with that question, and you want to get a good grip on those. Then we come to the most important part of the case brief itself, which is the holding. And that's where you're going to be able to get the key pieces of the decision that are going to be helpful on your law school exams, creating your outlines, and then ultimately being a good practitioner and a good lawyer. Here I've broken the holding down into a few pieces. So first of all, who wins? So the Supreme Court has made this decision. Which of the parties wins? Is it the appellant, and are they satisfied with the decision, or is it the appellee, and they were successfully able to defend their position from the appellate level? It may also be that both parties are neither winners nor losers. Maybe some pieces are affirmed, some pieces are reversed, and it's worth being able to note that, because that person or that party ultimately is going to be one that's going home happy or unhappy. Then here's a piece that you also want to think about. What are the next steps? The Supreme Court is going to say that the judgment is reversed, or the judgment is affirmed, or it's reversed and affirmed, and then it will remand the case back down to the trial court to figure out what's being done with it. Or they may remand it down to the circuit court for them to figure out what's done with it, especially if there's really one specific question that the Supreme Court is asking. So sometimes, for instance, the trial court could be going on and the trial hasn't resolved, and there's an appeal right in the middle of the trial. So the trial gets put on ice, and then the appeal gets taken up, and it gets brought to the Supreme Court, and the answer is resolved, but then it's got to go back to trial, and the trial's got to resolve itself. So it's almost like the trial judge is waiting for the Supreme Court to weigh in before a decision is made. So you have to know, where is it going after this? Then you also want to figure out what the precedent is. Now remember, precedent from a case is really just, what did the Supreme Court decide? What is it that the court decided with regard to the law? And as you get used to reading cases, you'll be better at spotting what the precedent is. So for example, in the Cruzan case, does the Constitution give a person the right to die? Or does the right of privacy give you the ability to say to a doctor, I don't want to have this treatment done to me? And in the case of Cruzan herself, who was in a catatonic state and was not able to make this decision for herself, can a family member, a close relative, or someone that has power of attorney, can that person do it? And if there is no power of attorney, who is the one that gets to call those shots? Is it the hospital? Is it the state? Or is it the family members? All of those are questions that the Supreme Court is going to answer in this decision. So the way to break down the precedent is pretty simple. The first part is to draft one sentence, basically a sentence that simply says, this is what the Supreme Court says. And in many ways, it's very easy to write this as a yes or no answer. So the court may say, for instance, does a person have a right to die? The answer is yes or no, because. And if you can answer that in a single sentence, you've done what you need to do for this section. This is a nice way of basically advising your clients. Your clients have come to you for a specific question and they want to know, what does the law say? Can a person withhold medical treatment or choose to withhold medical treatment? And based on the Cruzan case, you're going to say yes or no because. And that's a really nice, short, pithy way of being able to say to your client, I know what the law is. Then this last piece is essentially an expansion of that sentence. This is your ability to summarize the entire case in a short paragraph. Oftentimes, when you're writing memoranda someday, you want to have these short paragraphs ready to go so that when it's time to cite the case, you can immediately copy and paste this paragraph because it's stuff that you've already done. It's work that you've already done in previous cases or building your practice portfolio, and it gives you an opportunity to work efficiently for your clients. This is also, too, where you're going to have answers created and ready to go for your law school exams. So this first sentence is what you would drop into your outline. This second paragraph or the second piece is where you would want to go to be able to use good argumentation in your law school exams. So going through the work now, figuring out what are the reasons, what are the principles that were informing the Supreme Court in rendering its decision, that's where you're going to be laying that out. And this, of all the things in the case brief, is the most important. If you do nothing else in your case briefs, you want to be able to do this short summary sentence, and you want to be able to state the principles of law. Because that, after all, is what you're going to be doing throughout law school, but especially in that first year. It's being able to see how these principles relate to one another. So that's basically the nuts and bolts of the core part of the case brief. Notice that this is the objective side of things. You're really just telling, what does the case mean, where does it come from, and what are the principles of law. Now, the second part of the case brief is your critical review, and this is where you take a step back. Now, I should say that most case briefs don't have something like this. Most case briefs don't ask you to dig into this sort of stuff, and most lawyers don't really dig into this stuff. But I highly recommend that you do this. And the reason why I recommend that you do this critical review is it makes you a better lawyer. It makes you a better practitioner because it makes you become more critical. You think not just what the law is right now, but what could the law be? In other words, you're thinking like a judge, or you're thinking like a member of Congress, or you're thinking like a scholar. You're thinking about what the future might hold for the law. And it also helps you understand the law better. In other words, you're being a kind of scientist of the law. You're being a philosopher in a lot of ways. You're looking beyond just what the plain black and white letters on the page say, and you're thinking much more about the ethics of things, how the cases fit into one another, how they affect real people, what they mean on the ground for individuals. So, on this left-hand path, or this critical review, I've broken it down into two sections. The first part you want to do is to consider the subsequent history. Oftentimes, once the cases are decided, most people don't go look and see what happens to the parties and what happens to the various players that are involved in this. So you might want to ask yourself, all right, what happened to the parties after trial? In the Cruzan case, some interesting things did happen. She eventually had her medical treatment withheld, even though the Supreme Court said that she really didn't have a constitutional right to have that decision made for her by her family. She did have a right to die, but that was only if she volitionally said that to her family, like in a power of attorney. In Cruzan's case, she didn't have that written down. So the state of Missouri could set up rules that basically said, without that, we can't withhold treatment. So in other words, the state had a higher interest in protecting her and her abuse, potentially at family members that were making the wrong decision, and their interest was higher than necessarily the individual person's interest, who we are not able to determine because she's in a catatonic state. And yet, Cruzan died. She ultimately had medical treatment withheld from her, and for an interesting reason, which is that the family just went ahead and did it anyway. They went ahead and pulled the plug, even though the law didn't really give them the right to. Now, the prosecutors technically could have prosecuted that family for murder, or at least a violation of the laws that gave Missouri the right to keep her on those medical machines. But they chose not to prosecute it. The prosecutor just chose to say, look, we're not going to even touch this case because optically and politically, it kind of sends a bad message. We're going after a family member who really was just trying to care for their individual person. I don't know, it's kind of problematic. So it's interesting to think about that. What it does is it says that, well, the Supreme Court decision might say one thing, but practice and the way in which people actually interact with the law might point a completely different direction. That tells you something about what the weight of law really looks like. The other thing that's worth looking at is, what did the government do after this? So once the decision is handed down, did the Missouri state legislature do anything with that? Did they change their laws? Were they waiting for the Supreme Court to weigh in before they overturned the law that forced that family to essentially keep her on those machines indefinitely? Or did the governor do something? In this case, we know that the state prosecutors chose not to weigh in, but were there other things that happened? There are a lot of things that government does do after the Supreme Court renders its decisions. Even if the Supreme Court says the Constitution requires this, Congress and other state legislators might nevertheless choose to look for certain holes or abilities to change the current law that are still constitutional, but maybe give new rights to people. So that shows us that law is actually a back and forth. This question is essentially showing you how the branches of government relate to one another. And it gives you a window into thinking about law not just as these opinions sitting around in books, but that it's a developmental process. So Congress passes the law and the president signs it and executes it. Then the Supreme Court interprets it, but it might cycle back around. And there might be a dialogue between the various branches. The same is true for the state level. So all of that is really important subsequent history that gives you a good idea as to how government relates with itself. Then you also want to consider jurisprudential questions. And what I mean by jurisprudence is basically philosophy of law, or how judges make their decisions. So here what we're asking is not so much what happened in the case, but what should have happened in the case. So what values might have the justices cared about? In a case that involves the right to die, there's going to be a lot of questions about what is life and what happens to a person when they die, and when does a person truly die? What actually counts for death? And the justices are going to have to wrestle with those questions. Even if they're not saying it, they're nevertheless thinking about these things. Why? Well, because they're humans and they're facing tough questions that humanity has always faced. And just because the Supreme Court says it doesn't just suddenly end those philosophical questions. So you might ask, well, what's lurking behind the text? What's informing this decision? Are there parts of the decision that you think were arguably incorrect? And in which case, why do you think they're incorrect? What values do you have that separate you from the justices? Do you find that you're agreeing with the dissenting opinion in the case and their values, for example? And then the question you want to also raise is, what are some philosophical or ethical problems that are raised by this? What are some interpretive problems? What are some things that the Supreme Court maybe needs to wrestle with in the next case? For example, if this creates an ethical problem for individuals that are on machines indefinitely, what could the next case look like? The next case, by the way, was the Terri Schiavo case, and that was a case that involved a lot of problems with the right to die, because in those cases, she was really very much just being kept alive by those machines. And there was a hard fight between members of her family as to what to do, and her status was turned into a political circus in a lot of ways by very powerful political figures who were trying to use it for their advantage. So you might ask in these questions, how far does this decision go? And when will the decision be reconsidered? What will the next case look like, essentially? Because that's what justices are thinking about, too. They want to think about how the law is going to impact things going forward. And then finally, if you were a citizen scholar, how would you handle this case? How would you advocate for revisions or adjustments to the law? Are there expansions that you would want to see? And are there ways in which you might want to see the case changed in some very important respects, not just from the holding itself, but also from the Constitution's perspective, from the legislator's perspective? What new laws would you want to see passed? And if there's problems with the Constitution, what would you want to see amended? In this particular case, it involves the right of privacy, which is not explicitly contained in the Constitution. So maybe you might walk away from this case and say, look, we really need a constitutional amendment about the right to die. A person has a fundamental right to decide what they do with their life and their body, and maybe the next of kin is the one that stands in the position to take on those decisions. Or maybe you go the other direction. Maybe people don't have a right to die. Maybe life is so sacred that you don't want people making those decisions hastily, and you don't want a family member to potentially abuse that sacred decision making, or worse, some medical doctor that's ill informed about those things. So that's what you're raising in these questions. You're thinking about the next case. And the advantage for doing that in law school specifically is it helps you prepare for your law school exams. You're not going to be answering these kinds of questions on the exam, but it's going to help you understand how your outline is going to fit together. It helps you see how all the cases interrelate to one another, and it gives you a much better way of kind of conceptualizing everything before you step into the actual exam room. So that's my quick and dirty tips as to how you work with the case brief. Again, these are just my recommendations. Ultimately, it's up to you how you brief a case, and there are a ton of resources out there that you can look at. But hopefully, I've at least given you some things to think about. Good luck writing your case briefs.